I'll let you know, we're going to take some brief, I guess, testimony from the parties. I'll let everybody know that everybody will have an opportunity to speak, so don't interrupt anyone else or don't interrupt the court. You'll have an opportunity to speak your piece. So on the, we do have the show cause hearing. We also have the motion for change of custody and parenting time. I'm going to address the motion first because that will be the easiest matter to get resolved. So Mr. Kelly, you can proceed with your motion.
Your Honor, essentially, that motion is based primarily on the issues we've had ongoing in relation to compliance with the court order and my client getting parenting time. It's directly and impacts the child custody factors, and I'll name the ones that are impacted due to this withholding occurrence. The love, affection, and emotional ties existing between the parties. It looks at the emotional bond. Him being prevented from seeing his kids is preventing him to continue that emotional bond and nurture that emotional bond, which he had prior to this latest withholding that has started back on December 27th. Factor B, the capacity and disposition of the parties involved to give the child love and affection that focuses on the ability to, again, parent to foster an emotional bond in the future. He's having a hard enough time in the present, again, because she's not keeping in compliance with the court order, and he's not able to see these girls to be able to have a solid relationship and foster that relationship. The length of time they've lived in a stable, satisfactory environment, I'd submit to the court, defendant's home is not stable, considering the allegations she's made that have been investigated by CPS twice, police twice, and both been denied. Nothing's come of it, which leads me also to the moral fitness of the parties involved, which ties into the same factor. We have to keep in mind, Your Honor, at the beginning of this case, he was charged with domestic violence in relation to her essentially going after him to get keys to his truck so she could get some pot and smoke it. As he's being arrested, she's telling him, "I want you to come home." He, of course, gets him on bond. He can't have any contact. Once the bond conditions get lifted, she's contacting him through text and saying, "Hey, let's meet you and the girls get together and we can go to the zoo or we can go to a park."
Okay, Mr. Kelly, how does this relate to your motion?
It's related to, Your Honor, again, the moral fitness involved, as well as the stable, satisfactory environment, in that she's accusing him of sex with girls. But before all this, she's wanting him to come home. She's wanting a relationship with him. She's wanting her family essentially reunified. Those two things don't jive together, Your Honor. And I would think that essentially it's a fabrication, which would go again to the moral fitness and also to the mental and physical health of the parties, Your Honor. You're making these allegations, these terrible allegations, but on the other hand, you're still wanting the same guy who's supposedly doing this stuff to come into your house. Finally, Your Honor, the unwillingness and ability to facilitate and encourage a relationship. Again, this is the fourth motion we're here this morning on, Your Honor, for him to see his girls. She doesn't follow your court orders. She withholds them for no valid reason. And she's clearly shown she's not going to facilitate a relationship between him and his kids. I think that's more than enough that gets us over the threshold of a change in circumstance or proper cause, because these things are having a significant impact on these girls' lives in terms of having a relationship with their mother. So we would request, as part of our relief, that you set this matter for an evidentiary hearing. We're also requesting during the interim that my client get temporary parenting time starting today, and that he continue to have them until the evidentiary hearing. That mom's parenting time be supervised at her expense, because she's clearly shown an unwillingness to follow your rulings or to comply with your court orders. I think if you don't do that, she's going to take these kids and run, and we're going to be in a bigger mess than we are today.
Okay, thank you. Ms. Couch, if you wish to speak to the motion.
I had some statements, but it's just what I had submitted to the court.
Okay, go ahead, tell me, and then.
Okay, would you like me to stand?
whatever you wish. If it's more comfortable sitting, go ahead, but speak up a little. So we can-
Okay, I said that his first statement was true, but the second statement that he said was false. I said I previously tried to change parenting time because of the videos the plaintiff had been watching. It was reported to Penfield's police department because plaintiff was previously residing in Penfield. I spoke to their sheriff where we looked at the videos together and he told me that he would be conducting a search and not to address the matter to the plaintiff because he would need time to get 2 search warrants, and the investigation was never done.
In the crowded courtroom, tension hung thick in the air as the judge took her seat, glancing over the file that had already tested her patience. The mother, who had repeatedly ignored court orders granting the father his rightful parenting time, stood defiantly with arms crossed, as if daring the court to challenge her. When the judge calmly addressed her violations, she instantly snapped back with a string of excuses, insisting she had the right to do whatever she wanted with her children. The judge remained composed, but her tone sharpened as she reminded the mother that court orders were not optional suggestions. Instead of backing down, the woman doubled down, raising her voice, interrupting the judge, and tossing out attitude like she was arguing with a neighbor not standing before the law. The room went silent when the judge finally had enough. She ordered the bailiff forward, informing the woman that her disrespect and willful disobedience had consequences. The moment the handcuffs appeared, her bravado shattered, and the courtroom saw the truth. Defiance has limits, especially when you try it with a judge.
To get your children from this couch.
Yes,
Have you called the police for their assistance?
yes.
What happened when the police got involved?
That she slammed the door in their face, denies them, and just tells them no.
Have you filed motions with the court to get parenting time?
Yes,
Has the court awarded you make up parenting time?
yes,
Most recently, did the court award you parenting time in January of this year?
yes,
Did you attempt to go pick the children up for that make up parenting time?
yes.
What happened?
She refused to give them to me again.
Do you approximately know how many days you have missed so far as simply your overnights for parenting time?
20.
Would you like the court to grant you some make up parenting time this morning?
Yes.
No further questions, Your Honor.
Okay. Ms. Couch, do you have any questions for the plaintiff? No?
The hearing opened with what should have been a straightforward procedural check, but the defendant seemed determined to make it anything but. He demanded to fire his standby lawyer, despite having chosen to represent himself weeks earlier. With dramatic flair, he insisted the court replace the standby counsel with someone who understands his sovereignty. The judge, having already dealt with his antics more times than she cared to count, reminded him for the 10th time that he was his own lawyer by choice. But he pressed on, adopting an exaggerated, self-appointed title that sounded like something out of a comedy skit. Native American Moroccan Royal Tribal Chieftain Esquire. His theatrics, meant to intimidate or confuse, only made the judge sigh in exhausted familiarity. She firmly denied his request and moved forward with the case, while the gallery sat amused at the spectacle of a man who tried very hard to sound important, yet failed spectacularly to understand even the basics of courtroom.
Heard him just testify that he has parenting time with your granddaughters, correct?
Correct.
Okay. Do you assist him in pickup and drop offs for
I do.
parenting time? Has there been occasions when you have gone with him to go get the girls and anything happened in regards to him actually getting the girls?
Prior to December 27th, yes. After December 27th, no, she refused.
Let's talk about prior to December 27th. What would happen?
We would go, then we were meeting at Riverside Park and we would wait for her to show up. When she'd show up, she'd let the girls out and they would come running up to Zach and we would take them.
Okay. Did something change after December 27th?
She just started refusing to give the give the girls. His first visit that he was supposed to was I'm not sure, but I got a text from Athena on New Year's Day saying
Okay.
that she was going to refuse to give the girls. Either she would not be home, he would text her and she would not respond, or if she was there, we'd knock on the door, she'd open the door and then just say no and slam the door in our face. So we would go back to the truck and call the police for the police to come out and assist.
And the police came out and assisted that help in terms of actually getting parenting time to occur.
No, she just did the same thing to the police.
Just to clarify, that he talked about prior to the December 27th date, and the court had previously entered an order which provided for makeup parenting time that stated that the parenting time would, again, the makeup would occur on January 27, 2025. And the plaintiff's motion states that he did appear on that date. Did you go with him on the January 27th date?
Yeah.
Okay. And what happened on that date?
She just refused. I don't know, either she refused or she wasn't there.
And you don't remember if she was not there or if she refused?
I don't remember that specific time.
Okay.
I have it written down at home, but I don't remember.
Okay. Ms. Couch, do you have any questions
I
of
do,
this witness?
yes. At what age did Zach Conley start wearing diapers?
The video begins with Karen entering the courtroom like she owns the place, head tilted high and confidence radiating off her in all the wrong ways. The judge tried to keep things civil, reviewing concerns over multiple parenting time violations, but the woman wasn't interested in listening. She cut off the judge mid-sentence, tossed blame everywhere except at herself, and even attempted to lecture the court on parental rights, as if the law didn't apply to her. Each outburst dug her deeper into trouble, yet she seemed oblivious to the escalating consequences. Finally, the judge leaned forward, voice stern, declaring that enough was enough. Within seconds, the bailiff approached, and the woman's face shifted from arrogance to disbelief. As she was escorted out, ranting about how unfair everything was, the judge calmly proceeded with the record. Because while drama may work on social media, it doesn't save you from contempt in a real court.
I am.
Ma'am, what we'll do is we're here to determine whether there was parenting time. That's the show cause, okay? So that's what the purpose of this hearing is. So you can ask questions about the parenting time, compliance with the orders, etc. Okay?
Okay.
Go ahead.
And you were at my residence on the 27th to pick up the children?
Oh, actually, on the January 27th?
Yes. Or
Yes.
December 27th. Or sorry, no, January 27th. I don't have anything written down.
Yes.
Okay. Even though the order was for the 29th. Wasn't that the
Whatever,
order that the judge put
whatever
in
day,
place?
whatever judgment day.
So you
I don't know
just,
specific dates, whatever.
and I slammed the door in your face how many times?
Twice that I went by myself once because that was at an appointment that
And
you slammed the door in my face. I have it on video, yes.
you came alone, correct?
I did that day,
Okay.
yes.
That was all I have. I'm sorry.
Okay, Mr. Kelly, any redirect?
No, Your Honor, no further questions, no further witnesses.
Okay, you may step down then. Thank you. Ms. Couch, do you wish to present any testimony or witnesses? No? Okay. Check that order because there was some, Ms. Couch, you raised some issues concerning the, I think it was the order of January 27th. I want to make sure if that was the time as well for the makeup parenting time. I believe it was, but
It was January 27th through February 9th.
okay, that's what I thought. And
I could have swore the pickup date was the 29th. I apologize.
well, I want to make sure that it's correct so that there's no issue.
But I was not home at the time of pickups.
And why is that?
Because he our children, and I don't believe that he needs any more parenting time.
Okay. You understand that there's an order for parenting time?
And if it was your children, you would be sending them with him?
Yeah, I'm just asking you a question. You understand that it was parenting, that it was ordered.
Didn't you deny that? Didn't you go on base and deny it after the fact?
Not the other particular orders. I did deny an ex parte order at one point, but there were subsequent orders to that.
The father sits quietly at his table, clutching documents he hopes will finally make a difference. He had followed every order, attended every hearing, and kept meticulous records of every denied visit. When called to speak, his voice was calm but tired. Tired of fighting for what should have been simple, time with his children. The judge reviewed his paperwork with visible concern, noting the number of ignored exchanges, unanswered messages, and fabricated excuses provided by the mother. The courtroom fell silent as the judge acknowledged the emotional toll placed on a father and, more importantly, the harm done to children by constant interference. It was a rare moment of validation, a moment when the system clearly recognized a parent who was doing everything right, despite being pushed to his limits by someone who refused.
Anything that was filed has been in the file.
I would love you to take that into consideration.
I would know for the court, I received no response to either of these pleadings for today's hearing.
Okay.
You got two in the mail.
Okay, the order is dated February 4, 2025. And it provided for makeup parenting time in Christmas Eve, Christmas Day, 2025. It also provided that the plaintiff would have the children with him on January 29th, 2025 at 6:00 p.m. until February 9th, 2025.
I have another question to ask you, sir.
Okay. Let me clarify that, because this is the order dated February 4th. Did you provide parenting time on the January 29th?
No, I did not.
Okay. And we had at the last hearing and addressed the issue of the CPS involvement. CPS, as Mr. Kelly has stated, has been involved twice before, and they've not had anything substantiated. Is that your understanding?
No, I have the CPS report right here, as well as Carla Titus's number. Now she said that her findings weren't. I need to take the kids to therapy, to get the whole picture, from the kids, them talking, them playing, them, interacting with a therapist. And so that way they can go, they can go on record. And they are in therapy at Summit Point. Now this has just started, but they've already, said some things. That was one of my questions. Do you have the report from Summit Point? They told me that I needed to sign a release so that way they could contact you.
Okay, I'm not aware of any.
As the judge addressed the mother's pattern of manipulation and obstruction, the woman erupted again, insisting she knows what's best and that the father didn't deserve custody time. She raised her voice, argued over every point, and even accused the judge of bias. The judge, maintaining nearly superhuman patience, reminded her that unlawful behavior cannot be justified by personal dislike. But the mother had no intention of calming down. She jabbed her finger, muttered under her breath, and even attempted to talk over the bailiff. That was the final straw. The judge issued a clear warning. One more outburst, and she would be held in contempt. Instead of taking a lifeline, the woman snapped again, louder, bolder, and completely unfiltered. The judge looked at the bailiff and gave a simple nod. Contempt charge granted.